And I read it now.
I can sit now. Can they hear you calling? Can they hear? Abdel, you? Yeah, good morning, Learned Council. Sit down, please. Can you hear me? Chief Kingsley.
Yes, my lord.
Oh, you can hear me? Okay.
Yes, my lord.
All right. Did you draw any person? Just say you draw it. Call number, appeal number 25.
25 2018. 20 and the state.
Yes, let me take the appearances of council.
May you please, my noble lords. My name is Kingsley Chuku. Chuku is spelled C-H-U-K-U. I appear with my learned friends, C-N-O-G. Oji is spelled O-J-J-I.
CN.
Yes, C-N, my lord.
Yes.
Oji, O-J-J-I, my lord.
Yes.
And T. Douglas Jaja Mrs. Douglas hyphen Jaja Mrs.
Yes.
T.B. Akinwumi.
T.
T for Timothy.
Yes.
For Tolu. B for blessing.
Yes.
T.B. Akinwumi. Akinwumi is spelled
No, that one. I'm coming from that
Okay,
area.
my lord, I'm grateful. My lord, we all appear for the appellant. We are grateful, my lord.
Yes. Appearance for the respondent.
My lord, my learned friend.
Any proof of service, registrar?
He just told me he's aware.
Yes.
He just
yes,
told me he's trying to hook up.
Is he from the Ministry of Justice?
Yes, my lord.
No, they shouldn't have no problem now. They should have IT personnel there. This judgment was prepared by me. It's a judgment against, it's an appeal against the judgment of the Bayelsa State High Court of Justice delivered by MAIMIA-J on the 24th day of January 2017 in charge number OHC3C from 2013. The appellant, who was the first accused in the trial court, was arrested, tried, and convicted along with others for the offenses of conspiracy to commit armed robbery and for armed robbery, which are offenses contrary to sections 444A and 3292 of the Criminal Code Laws of Bayelsa State 2006. The case of the prosecution against the appellant and his co-accused, as narrated by PW1, who was the victim of the offense, is that on the 9th day of December 2012, the appellant approached him and requested that he, thus PW1, should convey him in a speedboat to Abobiri. They negotiated and settled at the fee of 20,000 naira, which the appellant paid. The appellant then told PW1 that his master would be coming from PortHarcourt and that they should wait for him. That the appellant then collected the phone number of PW1 and left, but later called at 5 p.m. and asked that they embark on the journey, but PW1 refused on the ground that it was late in the day. That the appellant then told the PW1 to rent a room in the hotel for the night. The PW1 went on to testify that the following day, the appellant came in company of two other persons who were identified as the second and third accused persons, and they started the journey to Agobiri at about 11 a.m. That between Agobiri and Igebiri, the appellant and his co-accused threatened him with a gun, pushed him into the water, and took away the speedboat. That the PW1 managed to swim ashore, where he reported the incident at the Igebiri police station, where he was directed to proceed to Inagua and report at the Marine police office, which he did. That it was sometime in 2013 when he saw the appellant at the burial ceremony in Okwama, where he was able to identify him, and that with the help of people around and the police, the appellant was arrested and taken to the office of the anti-robbery squad in Inagua. The appellant literally denied any involvement in the robbery alleged by the PW1. At the trial, the prosecution called 3 witnesses and tendered 17 exhibits, including the extrajudicial statement of the appellant, which was admitted as exhibit PR15. The appellant testified in his defense, but called no other witness. At the close of evidence, the respective counsel filed and exchanged written addresses, and you consider judgment delivered on the 24th day of January 2017. The appellant and his co-accused were found guilty and thus convicted for conspiracy to commit armed robbery and accordingly sentenced to death. Agreed by decision of the trial court, the appellant has filed this appeal. The original notice of appeal, consisting of 3 grounds of appeal, was filed on 10th of April 2017. I hope counsel are hearing me. I hope counsel are hearing me. Mr. Chukwu.
Yes, my lord.
Are you hearing me?
Yes, my lord.
Okay.
The respondent counsel is also.
Okay, I will record his appearance later.
Okay, my lord.
Same was, however, amended by a leave of this court
As my lord
on 30th
pleases.
of April 2020. This appeal was therefore heard on the amended notice of appeal filed on 30th of April 2020, consisting of 6 grounds of appeal. In obedience to the rules of this court, the parties filed an extended brief of argument. The appellant's brief of argument was filed on 4th May 2020, and 3 issues were raised therein for determination. 1, whether the judgment of law court is against the weight of evidence. 2, whether the prosecution proved the charges of conspiracy and armed robbery, thus see piracy against the appellant beyond reasonable doubt, taking cognizance of ingredients of the offenses. 3, whether the conviction of the appellant based on his alleged confessional statement, Exhibit PR 15, is proper in law, having not been made pursuant to Section 17(1) and 2 of the Administration of Criminal Justice Act 2015. There is a competent appeal before this court to whether the judgment of the lower court is not against the weight of evidence. Before I proceed, I wish to note that the respondent had filed a notice of objection on 8th of July 2020. However, on the 23rd of February 2021, when this appeal was heard, learned counsel for the respondent did not argue the said objection as required by law. We know the consequences of that. The preliminary objection was therefore deemed as having been abandoned and accordingly struck out. I also wish to point out that instead of arguing the preliminary objection separately in the respondent brief of argument, learned counsel for the respondent raised and argued same as an issue for determination in the appeal. That is not the law. A preliminary objection can never be an issue for determination in an appeal. So that issue is hereby struck out. At page 7 of judgment, I noted that the appellant argued, I noted that the appellant argued the 2 issues of conspiracy to commit armed robbery together with the substantive offense of armed robbery. The Supreme Court has enjoined several times that when a charge of conspiracy to commit an offense and the commission of substantive offense are charged, you have to consider the 2 of them separately, because both of them are substantive offenses on their own. Therefore, you cannot argue them together. Therefore, in doing that, first of all, and we have been enjoined to also consider the substantive offense first, which I did by considering the argument in respect of the charge of armed robbery. So the first issue that was raised is whether the evidence, the state confessional statement, offense section 17(1) and 2 of the Administration of Criminal Justice Act 2015. We all know that the Administration of Criminal Justice Act 2015 applies to only federal courts, the High Court, the FCT, and the other federal courts. It does not apply to High Court of a state, except where that has been domesticated by that state. Well, it is also to be noted that the offense was committed before 2015, and the statement of the appellant was recorded before 2015. And the administration of criminal justice cannot operate retrospectively. Therefore, it is not proper to argue that something that was done before 2015 was not done according to the law that was enacted in 2015. In doing that, I relied on the dictum of my Lord Sankey, just here. I will quote it here. I must say that contrary to the erroneous contention of the Respondents' Council, the Administration of Criminal Justice Act, being a statute containing provisions on practice and procedure, is capable of being applied retrospectively. But it must be noted that any retrospective application of the ACJA, being a procedural law, can only affect proceedings pending before the court and not in relation to action already taken by the court or litigant pursuant to the Old Criminal Procedure Act. As a matter of fact, if at the time a party or even the court took any action in relation to the proceedings before the court, the subsequent act has not commenced, it will be a folly to effective administration of justice to expect that the action properly taken under the old act will be deemed invalid merely because there is a new law regulating the action and which provides for new ways in the proceedings must be conducted close of court. On the whole, therefore, the provisions of Administration of Criminal Justice Act 2015 could not apply to the proceedings leading to unsuitability of PR 15 at the time same was tendered and admitted. This issue is therefore resolved against the appellant.
As the court pleases.
Yes, in considering the substantive offense, some issues were raised, especially on the issue of the confessional statement. And I've considered the arguments, the law applicable, the issue of contradictions mainly was that it was contended that the land council that the fact of robbery was not proved. In other words, that the evidence adduced by the prosecution did not prove the fact of robbery charge. They said that he was robbed of the speedboat on 10/12/2012. The PW stated that it was on the 9th of December 2012 that someone called to tell him that pirates attacked the driver of his speedboat and we all know that for a contradiction to be fatal to the decision of court, it must be substantial and material and must touch on the root of an essential element of the offense. So the fact to be proved here is whether there was an armed robbery against PW1. Please, there's so much noise there. Please. Somebody is making noise. In other words, the material or substantial issue here is whether there was an armed robbery. If the fact of armed robbery has been established, it will not matter that one witness says that it was on the 10th, while another says that it was on the 9th day of December 2012. In any case, the discrepancy between the parties stated is not substantial as to lead to the rejection of the material evidence on the fact in issue. The land trial judge was there with a minor discrepancy which has no adverse effect on the evidence adduced by the prosecution. On that note, I hold that the fact of armed robbery was established by the evidence on record. So what remains to be determined is whether the appellant was one of the three persons that was robbed PW1 on 10th day of December 2012. It therefore brings to the fore the issue of identity of the appellant as one of the persons that committed the offense charged. So the issue of identification is an essential and fundamental issue in any proceeding, because the identity of the accused person as a culprit in the commission of offense charge is therefore a critical and important issue in its prosecution. That's why the Supreme Court has insisted that before a person can be convicted for any offense, the court must test the evidence of identity in the light of other evidence adduced at the trial carefully and evaluate the same, so as to ensure that the person in the dock is the person who was seen committing the offense charge. I consider the decision of the trial judge on the issue. I found that there is no doubt in my mind that the appellant was properly identified as one of the persons that brought PW1 on 9th of December 2012. Indeed, the appellant was the planner and architect of the entire robbery operation. He induced and drew out the PW1 to a convenient in court place where he, that's appellant, and his co-travelers dispossessed him of the speedboat after threatening him with the gun and push him into the sea. It is apparent, as rightly pointed out by learned trial judge, the PW1 was in physical contact with the appellant for 2 days in broad daylight and for a reasonable length of time. The ill-fated trip was also in broad daylight, so it was not surprising that after a period of 2 months, the PW1 could recognize the appellant. Furthermore, there is no evidence on record to the effect that the appellant disguised or covered his face at any point in time during his interaction with PW1. I'm therefore satisfied and do agree with the land trial judge that the appellant was properly identified beyond reasonable doubt as one of the persons that robbed the PW1. So that is that for the issue of identification. So apart from the evidence of identity of the appellant, the trial court appeared to have relied on the confessional statement of the appellant exhibit that the law recognizes the court can properly convict solely on the extrajudicial statement of a person where such statement positively, directly, and unequivocally shows that the accused person has admitted to have committed the offense charge. So before such statement can be validly right one to convict, it must have been duly proved in the sense that it was validly admitted in evidence. That is why learned counsel for the appellant has now argued that the said extrajudicial statement of the appellant was not validly admitted. The learned trial judge in the course of the proceeding, particularly when the appellant was giving evidence, recognized that the appellant could not appreciate the English language. That it shows that the appellant gave his statement to the police through an interpreter. I have carefully perused the record of appeal. At the time the appellant's plea was taken, there is nothing to show that the appellant could not understand the English language. He was duly represented by Kayode Olaoshibikan, Esquire of counsel, but the said counsel never raised the issue. At the time, PW3, who recorded the statement of the appellant, satisfied. He told the court he cautioned and recorded the statement of the appellant in the English language. At this time, the statement exhibit PR15 was tendered. The ground for objection to the admissibility of the statement was that, I quote, the confessional statement is in contravention of section 29 of the Evidence Act 2011, and so it could not be, it should be rejected by this court. The confessional statement was obtained illegally by torture of the accused person, and so we are asking for trial within trial to determine the admissibility of the statement. There was no objection on the ground that the appellant did not understand English. Furthermore, the PW3, the investigating police officer who recorded the statement of the appellant, did not say that the appellant made the statement to him through an interpreter. Surely the person made a statement through an interpreter both the recorder of the statement and the interpreter be called to testify. Otherwise, the statement recorded will be hearsay. But that is not the situation in this case, because there is no evidence that an interpreter was involved when Exhibit R15 was recorded. Even at the time the statement was tendered, the appellant never asserted that he made the statement which he alleges he was forced to make. He did so in a language other than English language. It therefore means that there was no involvement of a third party between the PW3 and the appellant when the statement was made. The logical consequence is that the rule stated in the authority cited above will only apply when an interpreter is involved in the recording of the statement. In the instant case, no interpreter was involved, and therefore the argument of the appellant has no substance. And therefore, the confession statement, Exhibit 15, was properly admitted. So having held as above, I'm of the view that the learned trial judge rightly relied on the confession statement to convict. I've dwelt on this extensively in this judgment. So I said at page 34 the judgment that courts have been enjoined, especially in cases of capital offenses, which carry the ultimate penalty, which is death, to carefully consider evidence adduced against the appellant before proceeding to convict. This is to avoid or at least minimize human errors, so that no innocent person is wrongly condemned. For as it is said, it is better for 10 guilty persons to be set free than for one innocent person to be wrongly convicted. That is why the law enjoins that where an accused person has resigned from a confessional statement, it is always desirable to have some evidence outside the confession of circumstances, no matter how slight, which make it probable that the confession is true. So my finding here is that in view of the properly and rightly too, the culprit in the commission of the armed robbery charge. Indeed, I had earlier found that the appellant was effectively linked to the commission of the crime, he having been duly identified by PW1.
What does it say? Just say
where there has been a clear
my audio.
In law, where there has been a clear, positive, and credible evidence which fixes the accused at the scene of crime, the trial court can validly convict as the person in the crime charge. The confession statement of the appellant has been effectively corroboratively proved the appellant was one of the persons that robbed Solomon area PW1 on 9/12/12. The latter trial judge rightly convicted him on the charge of armed robbery. I considered also the charge of conspiracy, the arguments of counsel, and the law applicable thereon.
Increase your body. No, okay.
My conclusion is that I have no doubt in my mind that the charge of conspiracy to commit armed robbery was proved beyond reasonable doubt. The learned trial judge was right when he found and held the prosecution proved the charge to prove their The learned trial judge was right when he found and held that the prosecution proved the charge of conspiracy to commit armed robbery beyond reasonable doubt. This issue is therefore resolved against the appellant. Having found as above, it is apparent that all the issues in this appeal have been resolved against the appellant. This appeal therefore lacks merit and is hereby dismissed. Yes. Consequently, the judgment of the State High Court of Justice delivered on 24th day of January 2017 in charge number OHC 3C 2013 is hereby affirmed.
The court pleases.
As the court pleases.
My Lord, we are grateful.
Thank you.
My Lord, we're very grateful for the wonderful judgment.
My Lord,
Yes, the council, let me take your appearance.
my Lord,
My Lord,
Respondents,
my Lord, I'm so sorry, my Lord. As at the
yes,
time,
yes, my Lord.
As at the time my Lord started sitting, I was unable to connect, so I didn't enter appearance, my Lord.
yes, I was informed.
My Lord, my name is CBAK, my Lord, Principal State Council.
C.
CBAK.
My Lord, that's not his matter. That's not his matter.
And that is not your case.
All right, my Lord, I'm so sorry. I'm so sorry.
That is not his matter. That is not his matter.
My Lord, I'm sorry.
From Bayelsa State.
I'm sorry.
Bayelsa
That's not your matter.
I'm so sorry. I'm so sorry.
Yeah.
They told me that it will be by 11. I'm so sorry, my Lord.
Yes.
Okay. So in this case, there's no appearance for the respondent.
My Lord, there is
my Lord, sir, the respondent is on.
Who is appearing for the respondent? In appeal number 25 CR, Timi
My
Oppo.
Lord, that is not my own. That's not my matter.
Okay.
I'm live. I'm live.
Who is appearing for the respondent?
It's
Beyond Duke.
It's Duke, my Lord, sir.
Beyond Duke.
I'm live, sir.
Yes.
Yes, my Lord, sir.
Beyond Duke.
Yes, sir. Yes, my Lord, sir. I'm live, sir. Can you hear me, my Lord?
Yes, I've noted your name.
Hello.
Beyond Duke for the respondent.
Yes, my Lord, sir. Thank you, my Lord, sir. Yes, my Lord, sir.
Okay.
Thank you, sir. I'm very sorry for coming late, sir.
It's all right.
We are grateful for the well-considered judgment, my Lord, sir.
Okay. Thank you. Okay. Hmm? Well, my learned brothers in the appeal have concurred with this judgment.
As God pleases.
As the court pleases, my Lord.
Call number 55.
CAPH Act 2018. Mr. Chimo Friday.
Shima will be.
Chimo Friday.
Yes, appearances.
May it please my noble Lord.
Yeah.
My name is Chief Kingsley Chuku. I appear with my learned friends, CN Oji, OJJI, T Douglas Jaja, Mrs. and TB Akinwumi elsewhere. For the appellant, my Lord.
May it please my lord?
Hold on.
CBAK. C. B.
Hold on a minute. Hold on a minute.
All right, my lord. CBD, as in Boniface.
Not appearing on the
CBAK.
screen.
AK
It
spelled
is
with H.
Uh,
EKEH.
TE.
CB.
Oh, CD.
CB, C as in come.
Okay.
B as in buy. AK, EKEH. EKEH. Principal State Council. Rivers State Ministry of Justice. I appear respectfully for the respondent. Thank you, my lord.
Well, this judgment was also prepared by me. The judgment, the appeal is against the judgment of Rivers State High Court of Justice delivered by Honorable Justice A.I. Yai Lamikara on the 14th day of 2018 in charge number 28 CR 2012. The appellant, who was the non-accused person in the court below, was charged along with 8 others for having committed the offenses of conspiracy to commit murder and for murder, which are offenses contrary to sections 324 and 319, sub 1 of the Criminal Code Law, sub 37 laws of Rivers State of Nigeria, 1999. Really, the case of the prosecution before the trial court is that on the 25th day of October 2011, the appellant conspired with others, some of who were at large at the time of the trial, to and did murder one Chief Benson A. Mwogu, the Ochimba Nihi Eche, by shooting him with an AK-47 rifle. That the incident was witnessed by 2 other persons who were with the deceased, one of who testified as PW4 at the trial. The other person was also shot and died from the injuries he sustained. The appellant at the trial denied participating in the murder of the accused of the deceased. At the trial, the prosecution called 5 witnesses and tendered the extrajudicial statement of the appellant, and same was admitted in exhibit as Exhibit R. The appellant also testified in his defense as DW6. At the close of evidence, learned counsel filed and exchanged written addresses, and in a judgment delivered on 14th day of May 2018, the appellant was convicted on the 2 counts of conspiracy to commit murder and for murder. Ruffled by the decision, the appellant has filed this appeal. The original notice of appeal, which can be found at pages 222 to 225 of the record appeal, was filed on 11 July 2018 and it contained 5 grounds of appeal. However, with the leave of this court, granted on 24th of April 2020, the said notice of appeal was amended. This appeal was therefore heard on the amended notice of appeal filed on the 20th of February 2020, but didn't file on 28th April 2020. Their parties thereafter filed and the same briefs of arguments. The appellant's brief of arguments settled by Chief Kingsley Chukwu was filed on the 6th of May 2020, and 5 issues were distilled for determination. The issues have been reproduced here. The respondent brief of arguments, which was settled by CBAK Esquire for Principal State Council, Rivers State Ministry of Justice, was filed on 22nd May 2020. Unlike the appellant, only one issue was raised for termination by the respondent and has been reproduced here. So upon a careful consideration of the issues formulated by the parties relative to the grounds of appeal, I will determine this appeal on the issues raised by the appellant. I wish to point out here, however, that the appellant also filed an appellant's reply brief on 29/5/2020. I shall refer to those arguments in the reply brief I found relevant. And in the consideration of this appeal, I shall consider all the issues together. I wish to also note, however, that the appellant and his co-accused were charged for the offenses of conspiracy to commit armed robbery and armed robbery. So I will consider the two offenses separately as stated in the case and the judgment just delivered. So in the terminal of this appeal, I shall begin by issue 3. I will consider by issue 3, then 4, 2, 1, and 5, in that order. So I considered the arguments of counsel. And at page 18 of the judgment, I said, by section 36(5) of the Constitution of the Federal Republic of Nigeria, every person who is charged with a criminal offense shall be presumed to be innocent and he is proved guilty. Court. By the presumption of innocence granted by the Constitution, the prosecution has the burden to rebut that presumption. So to rebut the presumption, the prosecution must adduce sufficient evidence to establish every ingredient of the offense charge. Where the evidence adduced fails to prove any of the ingredients, it means that it has not been proved. Particularly in the criminal charge, where the life of the citizen is at stake, the court is enjoined to meticulously and scrupulously evaluate the evidence so as to ensure that an innocent man is not mistakenly convicted. No doubt human error cannot be completely ruled out in the course of taking judicial decisions, but the judge must be seen to have acted on the evidence judiciously and judicially, having regard to the rules set out by the law to ensure that such human errors are reasonably ruled out. That is why the law requires what proof beyond reasonable doubt means. And I've also written down what are the modes of proving the commission of offense, which are one by evidence of an eyewitness, by confession of the accused, or by circumstantial evidence. So where evidence has been adduced, the trial judge has the duty of evaluating the evidence, and this court will not intervene unless the judge has failed in the evaluation of evidence, or if the evaluation of evidence has not been proper, or the evaluation of evidence has led to a miscarriage of justice. So to prove a charge of murder, it must first be proved that a person has died, that the death of the person resulted from the act of the accused person, and see that the act of the accused that resulted in the death of the person was either intentional or with the knowledge that death or grievous bodily harm would be its probable consequence. All the above stated ingredients must be proved beyond reasonable doubt. In the absence of proof of any of those ingredients, the accused will be entitled to an acquittal. I found from the evidence that there's no doubt that the death of a human being had taken place. Particularly, PW1 Mr. Fred Mwogu testified that he's the son of Chief Benson Anyele Bechi Mwogu, and he gave his own side of the story of how the death occurred, though he wasn't an eyewitness. But there are some documents, the medical report and all this showed that somebody has died in the person of Chief Mwogu. So the next ingredient to be established is whether the appellant is one of the person that killed Chief Benson Mwogu. I've considered the law as required on proof of identity. And I will read the finding of the learned trial judge on the issue of identity. At page 26 of the judgment, the learned trial judge said, I quote, "This takes me to the evidence of PW4. PW4 and one other person were with the deceased in his palace when the deceased was killed. Unfortunately, the other person who was also shot during the incident died. The PW4 gave an eyewitness account of what happened on that day, which I have summarized earlier in this judgment. The veracity of the evidence of the PW4 as to what happened in the palace of the deceased, which led to the death of the deceased, is not in doubt and was not impugned by the defense. The only area that created a doubt as to the identity of the man the PW saw that day, PW4 had earlier stated in the brief of evidence attached to the information that although the three men were not wearing masks, he could not identify their faces. But in his evidence before this court, he stated that two of the men were masked and one did not. He stated that he saw the face of one that did not wear mask and later identified the non-defendant in an identification parade at the police station. The original statement of the PW4 is that he could not identify the three men, though I tend to believe this because the PW4 in his evidence told the court that Ghost Power James, who was with him in the palace of the deceased when the three men entered, was shot because he looked at the face of not wearing a mask. It is pertinent to state that because he stated that he could not identify the three men he saw on the day of the incident, would not detract from his eyewitness account of what happened at the palace of the deceased, leading to the killing of the deceased. I believe the evidence of PW4 that as they were with the deceased in his palace in the evening of 25/10/2011, three men came in and in their attempt to drag the deceased outside, as the deceased struggled with them, they cut the deceased with a knife and shot him, close of court. There is no doubt that the PW4, who gave an eyewitness account of the killing of the deceased, testified that an identification parade was conducted wherein he was invited by the police to participate, and that he did identify the appellant as one of the persons that killed the deceased. He testified at pages 153 of the record of appeal as follows, and I quote, "On 25th October 2011, my uncle, Barrister Obu Achongwa, sent me on a message to Ochimba 1 of Nihi, Chief B. Mwogu. I went there with Ghost Power James to deliver the message. As I went there to deliver the message, we heard the sound of motorcycle inside the palace. We saw three armed men come inside the palace. Two of them wore masks, while one did not wear mask. The two of them wearing masks went to Ochimba. The other one, not wearing mask, told us to lie down. We were sitting down then. The two of them wearing masks dragged the Ochimba. They were trying to drag him out, but he was resisting. They then cut him with a knife and shot him. The other one, who was not masked, started collecting our phone. As I'm giving him my phone, I looked at his face, close of court." The PW4 then stated at page 134 of the record of appeal as follows, I quote, "The next day, police came and I told them what I saw. They asked me if I can identify the one I saw his face, and I said I can. I was also invited to the state CID. They brought out 10 persons and I identified the person I saw that day. They asked me if I know him before the time, and I said no. He was asking what he did that the police called his name, Shima. It was the 9th accused person I saw that day, close of court. Under cross-examination, the PW by Mr. Adams of counsel for the first, second, and seventh accused, the PW4 stated, I quote, I was present when the incident happened. The incident happened about 7 p.m. There was a lantern in the room. I was able to identify the accused person, close of court. The PW4 also stated under cross-examination by learned counsel for the 5th, 6th, and 8th accused person that it was when he was giving his phone to the person who was wearing a mask that he was able to see his face. He repeated that statement when he was cross-examined by counsel for the appellant. The PW5 who was the investigating police officer, confirmed that there was an identification parade in the course of the investigation, and the 9th accused person, who is the appellant herein, was identified. It should, however, be noted that learned counsel for the appellant contended that the evidence of PW4, the one of the person that killed the deceased, is contradictory. That while PW4 stated in his extrajudicial statement to the police that he could not identify the appellant, he testified in court that he was not masked at the time of the incident. Yes, I also considered what contradiction is. So in the instant case, the material issue in contention is whether the PW4 was able to identify the appellant as one of the persons that committed the murder charge. There is no doubt that the PW4 stated in his statement to the police, Exhibit M, that he could not identify them in person. He stated as follows: they cannot identify them in person. They wore big clothes to conceal their guns. They were not marked, but I cannot identify their faces. The boys are of average sizes and height, close of court. The statement was made on 26 2011, one day after the murder. A careful interpretation of the statement of PW4 does not appear to me that the said witness made a categorical statement that he could not identify any of the appellants. He stated that he could not identify them in person in court, which in my view could only mean that he could not recognize any of the assailants. Recognition simply means when a person sees or acknowledges the identity of a person well known to him committing a crime. Evidence of identification by recognition is therefore the best evidence of identity of an accused person. So the issue as to whether the appellants were wearing masks or not is not, in my view, a material fact. The material fact is whether or not, in the circumstances, PW4 were able to identify the appellant as one of the culprits in the offense charge. The evidence on record show that PW4 stated in his statement to the police, appellants were young and of average height, weight, and height. He also informed the court that he was at the police station and was able to pick out the appellant in an identification parade. The appellant did not cross-examine on that issue, nor did he lead any evidence to discredit the identification parade conducted. In other words, it was never the case of the appellant that no identification parade was conducted, or that if there was any, that it was not conducted in accordance with the law. The fact of identification parade was corroborated by PW5, who stated that an identification parade was conducted and the 9th accused, thus appellant, was duly identified. Therefore satisfied that the appellant was properly identified beyond reasonable doubt as one of the persons that murdered or killed Chief Benson in Wugu on the 25th of October 2011. Well, apart from evidence of identification, there's this confessional statement of the appellant. Mr. Chuku again brought in this issue argument on section 17, but this time that of administration, River State of Administration Criminal Justice Law. My finding here again is that the events leading to admissibility of Exhibit R were done before 2015, the date the law came into effect. I also found that in view of the identification of the appellant, the confessional statement was duly corroborated. So at page 41 of the judgment, I concluded on this as follows. It should be remembered that the non-accused person referred to in this judgment is the appellant in this appeal. I had earlier found in this judgment that the appellant was effectively linked to the commission of the offense of murder charge, he having been duly identified by PW4, an eyewitness to the commission of the offense. In law, where there has been a clear, positive, and credible evidence that fixes the accused person at the scene of the crime as a participant to the commission of the offense, the trial court can validly convict him. In the instant case, the appellant having been clearly and credibly identified as participant in the crime charge, the confessional statement of the appellant has been duly and effectively corroborated as being. On that note, it is my view that the evidence on record sufficiently proved that the appellant was one of the persons that murdered Chief Jameson A. Mwogu in his palace at Nihi Eche in Okehi Judicial Division of Rivers State. The learned trial judge was therefore right when he convicted him for having committed murder, contrary to section 319(1) of the Criminal Code Law, Chapter 7, Laws of Rivers State of Nigeria, 1999. Consider conspiracy. And so upon a careful consideration of the total of the evidence on record, that the findings of the trial court cannot be faulted, there was ample evidence from eyewitness attendants in his part cannot be faulted, as the evidence in W4 was able to identify the appellant and identify it as a participant in the crime charge. The testimony of PW4 was never controverted, nor the question of the appellant Exhibit R, which was treated with that substantially. And is permitted from that for which the conspiracy was such as immaterial. From the evidence on the record, I have no doubt in my mind that the prosecution proved the charge of conspiracy on the standard required by law. I therefore hold that the learned trial judge was right when he found and held that the prosecution proved the charge of conspiracy to commit murder beyond reasonable doubt. This issue is accordingly resolved against the appellant. Having found as above, it will be seen that all the issues in this appeal have been resolved against the appellant. This appeal is therefore unmeritorious and is hereby dismissed. Consequently, the judgment of the Rivers State High Court of Justice delivered on 14th day of May 2018 in charge number OHC 28 CR 2012 is hereby affirmed. My learned brothers, Honorable Justice Paul Obi Elechi and Gabriel Omoni Kolawole have concurred with this judgment. This is the judgment of the court. No, we have not. Yes. Mr. Chuku.
We are grateful, my Lord.
Thank you. Mr. Eke. Okay. So the court will rise.